to the next speaker, who is Daniel White, a local West Australian who is a specialist employment and industrial relations lawyer. A very good career path, if I may say so. Daniel is a special counsel with Mills Oakley in Perth and has a Bachelor of Laws from UWA and a Masters of Employment and Labour Relations Law from the University of Melbourne. He is keenly involved in debates on industrial relations reform and federalism, and his topic today is workplace rights and the states. Please welcome Daniel White.
Thank you very much, and it's an absolute honour to be speaking here today, so thank you very much to the committee for the invitation. It was at the May 2006 Samuel Griffith Society conference in Canberra that Stuart Wood QC delivered a speech that predicted that the majority of the High Court would dismiss the state's appeal in the Work Choices case. He was right. A majority of 5-2, the court handed down their decision on 14 November 2016, dismissing the appeal. In effect, the High Court validated the Howard government's assaults on the states, essentially stripping them of almost all rights to legislate in respect of industrial relations and employment for corporations and their employees. This result was 85% approximately of private employers in Australia being quarantined to the federal industrial relations system. This meant a very big change for some. The following year, 2007, at the Melbourne conference, Eddie Gisonga and Julian Leeser, now MP, and John Garver separately provided their views of the outcome of the Work Choices decision, both in terms of political posturing by the states, their approach to the appeal, and the High Court's application of principles of constitutional interpretation. Today, just over 10 years now from Work Choices, presents an appropriate time to revisit and reflect on what occurred, how the states responded, whether the Commonwealth has been more effective in dealing with workplace rights in the states, and what can we look for in future in terms of possible change. All of this in 20 minutes. But my paper does go into much greater detail. So let's look at some background. Work Choices. The Workplace Relations Amendment Work Choices Bill was introduced into Federal Parliament in 2005. The bill, amongst other things, sought to establish a minimum national standard called the Fair Paying Conditions, as well as displacing the state award system by preserving them as federal instruments. The more controversial aspects of the legislation included limiting access to unfair dismissal, reducing the role of the Australian Industrial Relations Commission, curtailing union influence, and having individual statutory agreements, called Australian Workplace Agreements, sit at centre stage. Historically, the federal system of industrial relations was only concerned with interstate disputes. Section 51 Placetum 35, the conciliation and arbitration power, was inserted into the Constitution by the founders after much debate. A power to, quote, for the prevention and settlement of industrial disputes extending beyond the limits of any one state. Prior to Work Choices, a federal system of awards existed that captured some corporations around the country. Other companies resided in the state industrial relations system. It should be noted that the Commonwealth unsuccessfully attempted by referendums on 6 occasions between 1911 and 1946 to gain greater power over industrial relations. In 1983, the Tasmanian Dams case was handed down, which has been described as the axe that sharpened and eventually delivered industrial relations to the Commonwealth. This case looked at the government's power to regulate in respect of trading corporations under Section 51 Placetum 20. Within a fortnight of that judgment of the case, the Federal Labor Minister for Employment and Industrial Relations commissioned a review into the remit of Section 51 Placetum 20. The review indicated reliance on this power to regulate corporations in respect of industrial relations and their employees was exotic. However, a series of High Court challenges to trade practices and industrial relations legislation reforms, relying on the corporation's power in part, to allow the Commonwealth to regulate this space eventually gathered momentum through the late 80s and the mid-1990s, building a case each time that the Commonwealth Parliament had the power to legislate as to the industrial rights and obligations of constitutional corporations. Thus, there was a hybrid in Commonwealth industrial relations regulation where the industrial relations power relating to prevention and settlement of disputes, with the corporation's power sustaining other aspects of the legislation in the Industrial Relations Act and the Workplace Relations Act related to agreements made between constitutional corporations, employees and unions. The phasing out of the reliance on the conciliation and arbitration power was all but completed with work choices. On 4 November 2006, the High Court, by a majority of 5-2, Gleeson, Gummo, Hayne, Hayden and Crennan, with Callanan and Kirby dissenting, dismissed the appeal by the states and upheld the validity of the legislation. As the Honourable Chris Jessup said, work choices was, quote, almost a complete abandonment of the conciliation and arbitration power as a constitutional justification for industrial relations legislation. The corporation's power in Section 51 Placidum 20 therefore offered an attractive way for the Commonwealth around the wreckage of its collapsed referendum proposals. The obvious straightforward method would be to regulate the employment relations of employers who were constitutional corporations, thereby bringing industrial relations of the vast bulk of the corporate sector within the purview of the Commonwealth. As Greg Craven wrote, in terms of federal theory, the Howard government's use of the corporation's power to implement its industrial relations program in work choices undoubtedly represents an historic breakdown in the traditional support of Australian Conservatives for the concept of federalism. That support has been based on a deeply held view that federalism is to be defended as a prime expression of conservative attachment to checks and balances as a means of limiting power. Work choices proved to be very unpopular with the electorate. In 2007, the ALP swept to power with a mandate for industrial relations reform. The replacement legislation, ironically called the Fair Work Act, fair for who I'm still trying to work out, commenced on 1 July 2009, with the remaining aspects commencing on 1 January 2010. The Fair Work Act continued and broadened its reliance on the corporation's power. I'll return to the Fair Work Act shortly. So what were the states' responses? What were the states' responses post-Work Choices decision? As Julian Lisa indicates in his 2007 paper to that Melbourne conference, the state Labor governments in Work Choices were always content for the Commonwealth to have power over industrial relations, and they pulled their punches in that case, in a constitutional sense, when it really required a full frontal attack. The state government rhetoric leading to Work Choices, both in and outside of the court, appears to have totally backflipped when it came to the federal Labor's broadening of the Fair Work Act. New South Wales, Queensland, South Australia, Victoria and Tasmania in fact passed legislation in 2009 to facilitate the uniform application of the Fair Work Act to all employers in those states, save for certain groups, public sector, judiciary, law enforcement and local government, other than Victoria. Northern Territory and ACT were already subject to the federal legislation in that field. The only state to remain firm and not to refer its powers to this day is WA. In fact, WA commissioned a review to carefully consider how it could retain legislative powers over industrial relations and employment. WA responded with two pieces of legislation, albeit with limited effect. Firstly, the Contractual Benefits Act 2007, restoring the capacity for employees of constitutional corporations to make claims for denied contractual benefits with respect to their common law contracts in the WA Industrial Relations Commission. And the second one, the Employment Dispute Resolution Act 2007, which provides employers and employees and organisations in both federal and state industrial relations systems with the option of resolving their disputes by way of mediation and conciliation in the WA Industrial Relations Commission. The fact is, Labor always wanted the Commonwealth to have power over industrial relations. It appears a Conservative government handed those reins in Work Choices with the disastrous long-term consequences for employers and employees. So the question has to be asked, has the Commonwealth been effective with workplace rights? The then WA State Liberal opposition leader said in 2005, quote, if we only have one federal system and the federal government of the day is Labor, then you are kidding to think that they won't hand over the industrial relations system to the union movement. If we continue to operate a dual system, then a future state Liberal government will no doubt provide a safety net for employers who would otherwise have been trapped by a federal Labor government union-based industrial relations system. And this, in fact, actually happened. As I said earlier, the Rudd Labor government swept to power in 2007 and delivered the Fair Work Act in 2009. In my view, it is a disastrous piece of legislation that cripples business, prohibits jobs, and promotes the failing union movement beyond compare of any other legislative scheme that ever came before it. But most of all, it demonstrates how the Commonwealth has failed not only to protect workplace rights of employers, but it fails to protect arguably the greatest workplace right of all, a person's right to work. The Fair Work Act fails in this regard for a number of reasons, including the minimum wage. It's out of control. It's too high for some struggling state economies and denies those companies in those states the opportunity to provide jobs. Secondly, penalty rates. They are job prohibitive, keeping a number of people out of work in circumstances where jobs would be available on ordinary rates. And the third one, minimum hours of work. It restricts jobs. In particular, the ability for young people to enter the labour force for the first time to perform work on weekends or after school. The so-called independent umpire, the Fair Work Commission, wields significant control under this system in terms of minimum wage setting, modern award content and approval of enterprise agreements. The Fair Work Commission has arguably demonstrated that it is not equipped to set the relevant standards across Australia. Minimum wage review decisions provide for increases that appear out of step and contradictory to economic data provided in the decisions. The so-called modern awards, which ironically again are currently being reviewed to implement plain English drafting, are now being used to implement broader agendas, such as domestic violence leave and anti-casual employment. It's also been suggested that the Fair Work Commission can be used as a political tool. For example, one must question the timing of the penalty rates decision and the phasing out of some penalty rates in light of the federal political cycle. After 10 years, one must sit back and reflect and answer, is Australian business and workers better off with the Commonwealth taking over industrial relations? For the reasons I've stated, I personally think not. The future. Our current industrial relations system is dominated and controlled by the Commonwealth is broken. Employers' and employees' workplace rights are not being adequately protected by a single government repository. Unfortunately, we have seen further assaults by the Commonwealth in this industrial relations related space. For example, the regulation of workplace safety. Again, WA remains the only state not to adopt the model unitary safety laws. The WA Labor government has recently indicated that it will hand it over. Surprise, surprise. Perhaps the referral of WA's industrial relations powers will also be the WA Labor government's agenda. I also suspect a future Labor government will take over regulation of labour hire, which is currently being considered by Labor state governments on a state-by-state basis. And then what will happen with the possible future regulation of the gig economy? The best thing for government to do in that tech space is stay out, but they will not be able to resist. So what are some of the possible solutions to restoring back some balance? Give powers back to the states in respect of industrial relations and allowing ultimately for policy competition between states and Commonwealth in respect of industrial laws. I could only imagine how better WA would be off for its employers if they had a choice to opt out of the Fair Work system and opt into a more competitive and flexible industrial relations scheme that would have likely have been introduced by a Liberal state government. How many jobs could have it saved? How many businesses could have it saved? At a particular time when iron ore prices fell, oil and gas took a major hit and 3 major resources construction projects came off the boil, perhaps we would still have a vibrant manufacturing strip down in Kwinana. There requires a political solution. Refer the powers back. The referring states can only revoke the referral of their industrial relations powers in certain circumstances. That is to reverse the effect of the legislation such that the affected employees would once again be subject to a state system. This includes the Fair Work Act being amended in a manner inconsistent with industrial relations principles set out in the referring states legislation and the intergovernmental agreement. An example of this would be if there was a reintroduction of AWAs at a federal level. But this is very limited and will only impact on around 15% of Australian businesses. In concluding comments, the Honourable Chris Jessup believes that industrial relations was a lot simpler under the old approach of Section 51 Placetum 35. Ideally, we need the Commonwealth to step partially out of the industrial relations arena. Businesses need choice. State governments are also much closer to the pulse of their economies and readily able to listen and respond to businesses, which differs from state to state. Perhaps there could be a federal national standards that applies to all employees and employers as some type of floor. Companies operating across borders can opt into the federal system. Parts of their businesses could voluntarily opt into the state system. One size does not fit all. But the key is that the system, whatever we have, must give flexibility and responsiveness, whilst protecting the rights of workers and business. Centralism never provides for this. The system is broken and the states must be provided with a greater role in industrial relations for the sake of our economies and for jobs. Thank you.